Today, we will be seeing some of the perfect karma moments when corrupt police officers met their match in the courtrooms and got owned for crimes they committed in uniform. Just like this sergeant who had no answers in his deposition.
We've got a complaint of you out here holding up profanities.
Okay.
I'm not going to tell you again. Okay. You have your ID on you?
I don't have
Put your hands right here.
Cops often commit atrocities, forgetting that they can be held accountable. Today we'll go through this shocking case where a corrupt officer faced swift karma in the courtroom, leaving him with nowhere to hide his misconduct. In December of 2018, a YouTuber named Otto the Watchdog stood on public property displaying various signs. Over about 30 minutes, drivers honked and waved, showing their support, but things were about to get dramatic.
And the Sheriff's Office dispatch.
Hi, there's some people out here at Interstate 30 and South Elm that have some very offensive signs.
Meanwhile, officers from the Roy City Police Department were called to the scene, and Officer Johnny Clark was sent to Otto's location.
Where's Johnny with the other one?
Should be right over here. Thank you.
Yes.
Some guy holding up a sign that says shit is f***ed up and stuff or something.
Still in office.
How are you?
Well, I was doing just fine until just a minute ago. I've already heard you say a cuss word once. So.
What do your other signs say, sir? Sir, what do your other signs say?
What am I doing?
Okay, can I see your other signs?
No, leave my feet away.
Sir, we've got a complaint of you out here holding up profanities.
Okay.
Okay, if you don't let me look at your sign, I'll take you in custody for disorderly conduct.
Otto was soon surrounded by officers who came to confront him about his sign. Otto firmly declined consent to the search and seizure multiple times, which infuriated Sergeant Dial. What happened next turned into a shocking standoff.
I'm not going to tell you again.
I'm not being disorderly.
Okay. I'm not going to tell you again. All right?
I don't consent to any searches or seizures.
Okay. This is offensive to people that are driving by. And families that are driving by.
Yes.
Yes, it's disorderly conduct.
What's the penal code?
It's disorderly conduct.
Can you read that to me?
It's disorderly conduct.
Okay.
You have your ID on you?
No.
Okay. Now you're failing the ID.
I don't have
Put your hands right here.
The situation escalated when the senior officer punched the signs out of Otto's hands. Evidently, taken by surprise, Officer Clark instinctively jumped back in fear.
Roll over. Since he's failing the ID, take him to jail for disorderly conduct.
When we're here answering a complaint and you refuse to identify yourself, that is a crime. When you're displaying these signs and people are calling because it's offensive to them, that is another crime. So yes, you have committed a crime. You committed two.
You didn't warn me.
We don't have to warn you. Ignorance of the law.
I asked you politely to see your signs and you said
I
no.
don't consent to any searches or seizures of my property or my person.
I'm not going to take you.
By laying down on the ground and indicating that he thought his intention was illegal, Otto opted for passive resistance. His message was clear. He wouldn't fight back, but wouldn't comply either.
Is that your cell phone and tripod? If it's not, I'm gonna leave it sitting here. If it is, I'm gonna take it and put it up so somebody doesn't steal it. But if you wanna act this way, I'll leave it sitting here and let somebody steal it.
Why would you do that?
Okay. We don't know whose stuff that is either.
I have a question. What am I being arrested for?
The officer just explained
Now's
it.
not the time to ask questions.
Oh, it is the time to ask questions.
You know what?
Nobody even asked me to identify. All he did is ask me if I had ID, and I don't have ID.
Let me explain something to you, young man. We're not holding court on the side of the road with you. Okay?
Well, you're arresting me.
We're not holding court with you.
I just want to know why I have handcuffs
Any
on.
questions you have, you can ask the jail or you can ask the court.
You gonna get up?
I can't.
Okay. Roll back over and I'll help you up.
I'm not sure if I can do that either. I would like to see your supervisor right now before you assault me any further.
We're not.
I am being assaulted. I have not committed a crime.
The officer made a questionable threat by saying he would leave Otto's camera at the scene for anyone to take it. This remark only made things worse for the officer.
I have not committed a crime.
Get up.
I have not committed a crime. I can't get up. You're hurting me. You are hurting me.
Then get up.
I cannot get
Then
up
get
like
up.
this. I can't
Get up.
like this.
They lift you up.
I'm trying to get up. Matt, please.
Get up.
Well, assist me up instead of trying to.
We're trying to help you up.
I cannot.
Lift you
I'm
up.
not trying to be an ass.
Yes, you are.
know what
I've seen the game before. Roll up to your knees and they will assist you up.
Roll up to my knees. I'm a fat man.
Okay.
Help me to my knees.
We already have one.
Well, help me again.
Now they'll lift you straight
On your
up. Feet. Stand up.
Okay, help me up. I have committed no crime. I have committed no crime whatsoever.
That's not yours. Remember, I asked you earlier. Come on.
You're gonna leave my shit on the side
Get
of the
in
road.
the
Get my
car.
equipment. Get my equipment. You dude, I'm asking for you to get my. Hey, I've committed no crime.
Unlock your car,
No
please.
crime.
You want to turn this phone off.
I ain't turning nothing off. I'm gonna leave it right like that. Put it in evidence.
According to cops, Otto was detained for not identifying himself. However, under the Texas Penal Code, a person is not legally required to identify themselves unless they are under arrest.
And if it was his, he didn't want to talk.
I heard it on.
Yeah,
Okay. You know where his car is.
somewhere up there. If I had to bet.
The law, you're still under arrest for failed ID.
I was under arrest, and then I ID'd, as the code says.
No, the code says when you're legally detained, you're required to ID yourself. You did not.
It specifically says arrested. I didn't do nothing.
What's your phone number?
I didn't do nothing.
Otto took a stand against the injustice by filing a lawsuit against Sergeant Dial and Officer Short for violating his First Amendment rights and malicious prosecution. The sergeant was then taken to a deposition where Otto's lawyer expertly dismantled his defense, leaving him completely exposed.
As I explained earlier, one, it was an officer safety issue because I don't know what the signs are made out of or what they were. And they could be used as a weapon. And secondly, we were still investigating whether a crime had been committed. And he was unwilling to show us what the other two signs or what the sign said other than what we could see.
Did you believe that Mr. Knowles had an obligation to give you those signs?
What do you mean, an obligation?
Did you have the right to see those signs?
Well, it's part of our investigation.
Did Mr. Knowles have the right to refuse showing you the signs?
Anybody can refuse anything.
Objection form.
Why did you hit the sign so hard?
Objection form.
Now, you would think that Sergeant Dial, after being 11 years on the police force, would be well versed in his knowledge about the law, but that is not the case. His lack of knowledge was blatantly obvious.
I don't know what your definition of hard and soft is, and that was 5 years ago.
How do you define hard and soft? You can use your own definition, please.
In regards to what?
The level of force that you apply to the signs.
I mean, I don't know how I would describe hitting a sign soft or hard.
Why didn't you use less force when touching the signs?
Objection.
I didn't know I used too much force.
Could you have used less force when touching the signs?
Objection form.
In regards to what? I mean, what was the amount of force that I used?
You said earlier that you conducted an investigation after you arrived on the scene that day with Knowles. What were the results of that investigation?
In regards to what?
In addition to violating Otto's First, Fourth, and 14th Amendment rights, the sergeant's complete ignorance about the laws surrounding disorderly conduct was painfully obvious.
Did you find anything during your investigation that caused you to arrest Knowles, that caused anyone to arrest Knowles?
Through our investigation, we determined that disorderly conduct had been committed
How did disorderly conduct get committed?
due to the verbiage that was on the signs, and we had received complaints.
His lack of knowledge showed that he was not qualified for the job.
If you received the same complaints and those signs had said something different, would Knowles have been arrested?
The same complaints in what? Because the complaint we had was, it was vulgar and offensive.
What I'm asking you is, if the complaints were the same, but the contents of the signs were different, would Knowles have been arrested?
Objection form.
What if the sign said Blue Lives Matter?
How is blue lives? There's nothing vulgar about blue lives matter. There's no profanity in blue lives matter.
Are you saying that if the sign said Blue Lives Matter, Knowles would not have been arrested?
I'm telling you that based on the complaints that we received that day, a guy telling me that he was offended by the profanity and vulgar that was being used in the signs.
Objection, non-responsive.
Sergeant Dial couldn't cite a single law that Otto had broken and claimed that the arrest was made simply because someone was hurt by the sign. Clearly, he needs to pick up a book on the Constitution.
If the complaints were the same, but the sign said Blue Lives Matter, would Knowles have been arrested that day?
Objection found.
There's no vulgar or profanity in in the verb or term, the verbiage or term Blue Lives Matter.
Do you think anyone that says a bad word publicly should be arrested?
No.
Why not?
Did someone complain on them, or they just out there just throwing a fit? No complaints. I mean, there's several reasons why we would not arrest someone. I mean, if nobody finds it offensive, then disorderly conduct's not met.
So if the language on the signs had not offended someone, Knowles would have been arrested, or would he not have been arrested?
So you're telling me we didn't receive any calls and nobody complained to us? Would we have arrested Knowles that day?
Correct.
No, we wouldn't have. Not have.
The lawyer held the sergeant's feet to the fire during the deposition, completely controlling it, but the best part was yet to come.
What specifically did Clark say to you about Knowles' prior disorderly conduct?
He was explaining it to Knowles that as I'm walking up, he's explaining it to him that, look, I've already heard you out here cussing at people.
So he was talking to Knowles, not you.
That is correct.
Did any motorists complain about the prior alleged profanities that Knowles said before you arrived?
Well, the one gentleman told me about the signs, and regarding what the people on 911 called in about, I do not recall that.
If anyone complained about verbal language and you didn't hear any allegedly profane verbal language from Knowles at the scene?
I did not hear it, but I heard Clark explaining to Knowles that he has already witnessed it or observed it himself.
The lawyer was ready to ask the question, leaving the officer speechless.
Do you know one word of profanity that Knowles said?
No, I do not.
And you are not aware of any person that was offended by what Knowles said?
No.
The sergeant dug his own grave when he admitted that the arrest was made based on the information on the placard.
Were you offended by the contents of his signs?
No.
Why did you think they were offensive?
The sergeant's mistakes continued to mount as the lawyer focused on the core issue of First Amendment rights.
So you would arrest somebody if a citizen complained about vulgarities?
Objection found.
So a citizen made the police department or dispatch aware that they had used profanities and vulgarities and were...
Been 5 people in your career?
I believe that would be an accurate statement.
Have you observed more than 10 arrests in your career?
I'd probably say I have observed more than 10 arrests in my career.
It is startling that a 10-year police veteran was unaware of the First Amendment. For the whole law enforcement community, this raises a crucial question of what sort of police officers are being trained and produced.
Have you observed more than 25?
That I don't know.
Have you observed more than 30 arrests in your career?
I don't know.
Do you remember any specific details about your training regarding First Amendment rights?
No, I do not.
Are you saying that you don't remember one word from your training regarding First Amendment rights?
Objection.
That is correct. We went over the elements of the Constitution, and I believe the First Amendment is part of the Constitution.
But specifically the First Amendment, you don't remember.
Correct.
Do you remember how long you spent studying constitutional rights?
No, I do not.
Have you had any training related to constitutional rights since you became an officer?
I do not recall.
For someone in such a high-ranking position, this officer's level of stupidity is astounding. How could someone with such a lack of knowledge be entrusted with authority?
What topics have you been trained on since you became an officer?
I don't recall all of them.
Name one.
Accident investigation.
Anything else?
I'm sure there's others.
Where did you receive the training regarding constitutional rights in 2007?
As when I was in the police academy, is that what you're referring to?
I'm referring to the training that you referred to, that you received in 2007 regarding First Amendment rights.
The Collin County College Police Academy.
And who trained you in constitutional rights?
Could not tell you.
Because you don't remember?
You're asking for the instructor's name? No, I do not remember the instructor's name.
This is the result of failing to get enough instruction on constitutional rights and the First Amendment.
Do you remember anything about the protections provided to citizens by the First Amendment?
No, I do not.
Are you aware that the First Amendment gives citizens what's known as the freedom of speech? Have you heard of the freedom of speech?
I have.
What do you think that means?
Interpretations are a dime a dozen, but basically someone can speak freely.
Following the deposition, the city was compelled to settle the case by paying Otto $25,000.
Does the First Amendment protect a person from being arrested because of what they say?
Objection form calls for legal conclusion.
Do I answer it?
Answer.
I think at times it may.
Has the police department provided you with any subsequent training on constitutional rights since you've been an active officer?
I do not recall.
Have you received any training, guidance, or instruction regarding First Amendment rights while you've been a police officer?
Objection form.
In the police academy, I know we went over the constitutional rights.
But anything since then?
I do not recall.
Moving on, here is a cop who was owned and sentenced in the courtroom.
To find the defendant Adam Coy guilty of as he stands charged in count 1 of the indictment.
There is no better feeling than seeing justice being delivered and a corrupt cop being held accountable for his actions. Today we will explore cases where these officers face life sentences in courtrooms for their despicable crimes. Starting off with the case of Columbus police officer Adam Coy, who shot and murdered 47-year-old Andre Hill in December 2020. Hill was unarmed and holding a cell phone in his hand. Just a week later, Coy was fired from the police department. Finally, in October of 2024, Coy's trial began. He was being charged with first-degree murder.
1 count of murder, classified felony. 1 count of felonious assault, felony in the second degree, and 2 counts of dereliction of duty, both misdemeanors in the second degree.
Okay, thank you.
Good afternoon, Your Honor. May it please the court. I am Mark Collins, 006-1207. Adam, can you hear us?
Yes, sir, yeah.
Previously, you gave me permission to sign your name to the not guilty form as well as the agreement to have your presence waived and go forward with the video conferencing today, correct?
Absolutely, and thank you.
Adam, however, pled not guilty to all 3 charges, and his defense team was now trying their best to get the least possible bond for him.
In addressing the first one, Your Honor, to assure someone's appearance at court, my client has no record in any way, shape, or form, Your Honor. My client voluntarily did a walkthrough of the scene on December 22nd, Your Honor. My client, in addition, gave a voluntary statement to the authorities, and then my client voluntarily met with the BCI agents for about a 2-hour and 15-minute interview. In addition, Your Honor, he was asked to turn himself in at an appropriate place and time in which he voluntarily did that. So everything that we've asked of him since December 22nd, Your Honor, he has done. In addition, when he was employed by the Columbus Police Department, he was required to go to a psychologist. He did that as well, Your Honor. In addition, Your Honor, we have his passport if the court would deem that, but it's clear that he's not a flight risk, Your Honor, and that he will appear for every and all court appearances, Your Honor.
Adam Coy was a police officer for 19 years, during which he faced 90 citizen complaints. His history of reacting aggressively under stress made it clear that releasing him from jail would pose a significant risk.
The court was guided to look at the nature and circumstances of this individual case. And that's important for this case, Your Honor, because these cases are unique. They're like no other cases that you normally preside over upon arraignments. And that they're unique, Your Honor, because this is not a whodunit or anything of that nature. It's simply whether or not our client was justified in using the force he did, and that will be determined, Your Honor, with a jury. So they're unique, Your Honor, because he's not arrested at the scene. As opposed, on December 22nd, he actually had to walk the BCI agents there. So it's a process that normally happens in these types of cases, Your Honor. Sometimes it could be a threat to the community. Sometimes the government might ask for a high bond based on potential threat. He's not a threat today, Your Honor. He wasn't a threat today when he met with the agents. He wasn't a threat when he walked them through. He has not been a threat in each and every doctor's appointment he's gone to in his interaction in the community. He has no access to guns, Your Honor. He has been terminated from his employment at the Columbus Police Department. So this unique situation of an on-duty use of force is not likely to happen again. Of course, he doesn't have a prior record, not on bond or anything of that nature, that the other factors to look at.
It was disheartening to see the defense attempt to frame the case as a routine act of self-defense when it was clearly a case of cold-blooded murder.
Your Honor, the closest thing this court normally comes to in cases like this is a self-defense case. Various self-defense cases that are currently in the system that we actually represent, Your Honor. We have bonds, people who are out on bond, anywhere from $25,000 to $250,000. And again, the only aspect in this case, Your Honor, is to determine whether or not the force that was used was reasonable or not viewed through the eyes of a reasonable police officer. And ultimately, a jury will determine that. Based on all those factors, Your Honor, we're requesting a reasonable bond. If the court has any other questions for us, I'm happy to answer.
Okay, thank you.
Finally, it was the prosecution's turn to address the judge, and they made a compelling case for raising the bond.
The difference, the state feels that the difference between those prior, goodwill things by Adam Coy and today is that today he is indicted for a felony, multiple felonies. He's indicted, and as you well know, the sentence, life sentence. So you can imagine that someone who is faced with that may have ideas of not coming to court. So that is the difference between this prior corroboration and where we stand today. As a result, Your Honor, the state is asking for a high bond in this case.
After hearing both sides, the judge finally decided, and it is quite safe to say that she stood with the right side.
All right, sir, I'm accepting your not guilty plea. I've considered the arguments by both sides with respect to bond. I am setting bond at $3 million surety or appearance, $20,000 recog, and as a further condition of bond, defendant shall have no contact and stay away from any of the witnesses or addresses identified in the indictment. Also, defendant shall have no contact with other police officers for the request. Thank you.
Good. Would the court consider the $3 million value, or maybe put on the record the components for that make up the $3 million, just so we have that for the next year?
I'm sorry?
Would the court consider lower than $3 million, or if not, would you put on the record some of the concepts as to why you picked the $3 million?
You know, that is based on everything that I've heard. That is the bond that I've set. If you wish to address it with the assigned judge, duty judge, feel free.
Appreciate
that. Thank you.
Thank you very much, Your Honor.
The judge did an excellent job, ensuring the cop received no special treatment. The $3 million bond was already a heavy blow, but things went from bad to worse as the trial unfolded and the jury delivered its verdict.
Count 3, reckless homicide. We have a general confusion on how to think of this concept and apply the instruction. 1. Can you define heedless indifference? The response from the court was heedless indifference is not a legal term, so you must rely on your everyday understanding and usage as to that question on behalf of the state. Where you can find the defendant was committing or attempting to commit felonious assault, you must find beyond a reasonable doubt that the defendant knowingly, 1, caused serious physical harm to Andre Hill, or caused or attempted to cause physical harm to Andre Hill by means of a deadly weapon. In other words, does the knowingly aspect of this statement apply to both aspects of the definition? And the response from the court was yes.
After answering the jury's questions, Judge McIntosh quickly moved to the verdict, which would surely grant some peace to the Andre Hill family.
As to count one, we, the jury, being duly empowered and sworn, do find the defendant Adam Coy guilty of murder as he stands charged in count one of the indictment, signed this 4th day of November 2024, and what appeared to be 12 signatures. Second count, we, the jury, being duly empowered and sworn, do find the defendant Adam Coy guilty of felonious assault as he stands charged in count two of the indictment, signed this day, and what appeared to be 12 signatures. The next verdict form. We, the jury, being duly empowered and sworn, do find the defendant Adam Coy guilty of reckless homicide as he stands charged in count three of the indictment, and what appeared to be 12 signatures.
Mr. Coy was found guilty on all 3 charges and faced the prospect of a long prison sentence, potentially life behind bars.
Your Honor, we would ask that you delay the enforcement with regards to any sentencing, Your Honor. Specifically, Your Honor, with regards to custody, Your Honor. As the court's well aware, he is in ongoing treatment for cancer. He has a PET scan, I believe, on the 12th, Your Honor. He has multiple appointments that he moved from during the trial till after, Your Honor. There's about, I think, 80 pills that he takes in combinations during the daytime and the nighttime. We would need some time in order to get that supply ready, Your Honor, if the court enforces the custody action. Your Honor, this is a situation in which he is in the middle part of a bone marrow transfer. It has partially taken. It's hopefully going to take. But we would ask that he remain. He has had no issues while in pretrial services, Your Honor. He has electronic monitoring on. He is not going anywhere, Your Honor.
The state requested the judge to revoke the defendant's bond, prompting his attorney to argue that he required numerous medication. Well, let's see how the judge responded to this plea.
I'd like to set a sentencing date. The court is not inclined to move forward with sentencing today. I don't know if there are victim impact statements that need to be provided to the court, or at least opportunities for victims to any documentation with respect to treatments that are scheduled.
Okay.
And then the court also is going to inquire of the jail to see what they're capable of. I've had those conversations previously with the jail for persons that have either been in some sort of treatment or have some kind of injury.
The other thing, Your Honor, we do have medication with us for tonight. Is it okay if we give that to the deputies now for them to administer?
Yeah, I don't want him to be deprived of any of his medications. I don't know who I'm going to need to have a conversation with to make sure that he gets the medications that he's been taking up to this point.
And just like the cop's bond was revoked and he was heading straight to prison, where he would wait for his sentencing day. On the other hand, this is how satisfied Andre Hill's family were after the verdict.
You don't get these sort of verdicts, so this is almost historic to get a verdict like this. Did it come as a surprise at all, or were you fearful that you wouldn't hear the guilty verdict that you wanted to hear?
No, I wasn't fearful because I know what I saw. I know what happened. I know what he did. So, I mean, there was no question in my mind.
What about the FOP president? He literally just said right before you came out, Andre wasn't complying. He was told to put his hands up, to show his hands, and he wasn't compliant. But well, the video shows something different.
The jury spoke different as well.
What's it been like to have to wait 4 years for this moment?
It's been way too long. It's been way too long, but I'm glad that it's over. I mean, it won't bring Andre back, but hopefully it will set a precedent across the board for everyone else. This is not something that we can tolerate.
When you saw Adam Coy walk back to the back of the courtroom and you knew he was going to jail tonight?
I didn't see him. We left the courtroom by then.
But so knowing that he will be behind bars tonight, what are your thoughts?
I'm glad. I mean, because at least he's still breathing. My brother is gone, so at least he still has his life. I mean, that's really not a fair trade, but it is what it is.
The sentence has yet to be announced, but it is clear it will likely result in nothing less than life behind bars. While this cop's life came crashing down, this next officer did something which will leave you speechless.
This is a case about an abuse of an incredible power.
This is Deputy Zachary Wester, who is accused of planting in the vehicles of innocent people, and he was ultimately charged with 67 counts of racketeering, trafficking, and disorderly conduct.
A substance that appears to be an illegal narcotic. Do you know anything about that?
I do not.
Have you ever seen this before?
No. No, what is that?
I'm just trying to figure out how that stuff got in your car. You're gonna go to jail today for possession of methamphetamine, okay?
Oh man, dude, I'm serious, dude. Anything, what you want me to do, man?
It's yogurt, sir.
I know. Okay.
It's yogurt.
How about this, though?
That is not mine.
The drugs were there. I did not put the narcotics there.
During his trial, over 12 people came forward and presented their stories to the jury, where they had been abused and assaulted by this monster. He was eventually found guilty on 19 of those 67 charges.
In the state of Florida versus Zachary Tyler Wester, case number 19-CF-431. We, the jury, find as follows as to the counts charged and the information. Count 1, guilty of racketeering as charged. Count 2, not guilty. Count 3, not guilty. Count 4, not guilty. Count 5, not guilty. Count 41, guilty of possession of controlled substance related to February 15, 2018 as charged. Count 42, not guilty. Count 43, not guilty. Count 44, guilty of possession of a controlled substance related to April 17, 2018 as charged.
Ladies and gentlemen, I want to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in your jury room.
Finally, after the jury reviewed each count, the judge took the stand and delivered his sentence, ensuring that he spends the better half of his life behind bars.
Court now sentences you as follows in this case. As to count 1, racketeering, which is a first-degree felony, you are sentenced to serve 5 years in the Florida Department of Corrections. As to count 7, official misconduct, that's a third-degree felony, you are sentenced to serve 18 months in the Florida Department of Corrections. That will be served concurrent with count 1. As to count 9, official misconduct. As to count 65, false imprisonment, that's a third-degree felony, you are sentenced to serve 1 year and 1 day in the Florida Department of Corrections, consecutive to count 64. Counts 7, 9, 10, 31, 33, 34, 41, 44, 48, 64, and 65 are to be served consecutive to each other for a total sentence in this case of 12 years, 6 months, and 8 days in the Florida Department of Corrections. This sentence of 12 years, 6 months, and 8 days in the Florida Department of Corrections is to run concurrent with a 5-year Department of Corrections sentence in count 1. Therefore, it is the intention of the court that you are sentenced to serve a total of 12 years, 6 months, and 8 days in the Florida Department of Corrections. I'm also going to award the defendant 58 days jail credit as to count 1 and count 7.
Zachary was sentenced to 12 years in prison with no chance of early parole. Moving on, this next cop did the unthinkable and was also sent away for a long time.
Having found the defendant Aaron York deemed guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days.
In the early mornings of October 12, 2019, Atiana Anderson was fatally shot inside her home by Officer Aaron Dean. The officer immediately resigned from his position and was arrested on a murder charge.
Y'all did fabulous when we did the guilt-innocence verdict, okay? Same rules apply. I don't know what this verdict is. Can't have any emotions, all right? Let's bring him in. Mr. Dean. Verdict reads, we the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days. They do not assess a fine. and it is signed by the presiding juror. You may be seated. Thank you very much.
Aaron Dean was sentenced to 11 years in prison as he was found not guilty of murder, but guilty of the lesser included offense of
Juror number 1, is this your verdict?
Yes, Your Honor.
Juror number 3, is this your verdict?
Yes, Your Honor.
Juror number 4, is this your verdict?
Yes, Your Honor.
Juror number 6, is this your verdict?
Yes, Your Honor.
Juror number 9, is this your verdict? Number 37, is this your verdict?
Yes, Your Honor.
Juror number 38, is this your verdict?
Yes, Your Honor.
Your verdict will be received and filed. Thank you very much. Mr. Gill, Mr. Brissett, is there any legal reason why sentence should not be pronounced?
No legal reason.
Mr. Dean, it's the jury having found you guilty of the offense of manslaughter and assessed this punishment. It's the order of the court you be remanded to the custody of the sheriff, be delivered to the director of the Texas Department of Criminal Justice to serve your sentence as required by law. You will receive credit for all the time that you have served in custody on this case from the date of your original arrest up until today, which would be the date of sentence.
It is shocking that this killer cop received only an 11-year sentence for murdering an innocent woman. The presence of a weapon beside her at the time of the shooting played a significant role in this outcome.
If you are indigent and cannot afford a lawyer, I would conduct an indigency hearing to determine if you are indigent. And if you are indigent, I would appoint a lawyer to represent you on appeal and provide you a record of this appeal of this trial at no cost. Is there an allocution? You may be seated. Thank you very much.
Next up, this corrupt cop thought he could bully anyone he wished, but had no clue he was heading to jail for a long time.
The court at this time will impose a sentence of 90 days, require you to pay a fine of $1,000.
Sinister cops are always owned and exposed in courtrooms. Their true face is revealed for the whole world to see. Today we'll be going through such moments where these corrupt officers got some brutal karma that knocked them down. Euclid police officer Michael Amiot was on trial after he was charged with assault when he physically used force on an innocent victim after conducting a traffic stop. It didn't take long for karma to hit him.
We, the jury, being duly impaneled and sworn, do hereby find the defendant Michael Amiot guilty of assault, a misdemeanor of the first degree, in violation of Section 2903.13A of the Ohio Revised Code, as charged in Count 2. We do so render our verdict this 29th day of July. We, the jury, being duly impaneled and sworn, do hereby find the defendant Michael Amiot guilty of interfering with civil rights, a misdemeanor of the first degree, in violation of Section 2921.45A of the Ohio Revised Code, as charged in Count 3. We do so render our verdict this 29th day of July, 2022.
Rightfully, the corrupt officer was found guilty on both charges, and the jury did a fantastic job.
That is your decision as to whether you wish to speak with them. With that, anything prior to discharging the jury?
No, Your Honor.
On behalf of the defendant, anything?
No, Your Honor.
Yes.
Amiot showed no remorse during his trial, and the very next day he was called back for sentencing. To make matters worse for him, the judge allowed the victim to say some words in front of the court.
My name is Richard Hubbard, and I appreciate the jury and the court for making the right decision. What Amiot did, something was wrong. He should have received the maximum sentences today. I'm still going through the suffering with the anxiety, driving, just the temperament, the trauma, and everything. This is a cause for this case. I'm ready to get it over, actually, but just coming back in here, just bring up everything, just to see him over there, see all that, just coming back in this court, just it just brings up everything, we live at the moment. So, I hope he gets the maximum sentences today.
This wasn't the end of it all, as the suspect, Michael Amiot, was also allowed to address the court and apologize. The cunning officer would still not accept his mistake.
One of the most shocking examples was a prosecution witness called who testified that I was celebrating in the aftermath of this arrest. They testified that I was high-fiving, fist bumping, and dapping it up with other officers. There was 5 police cars on East 228th Street that day, all with their dash cameras on and rolling. They all had overlapping fields of view. I can be seen in front of one of those cameras the entire time I was on scene until I was transported to the hospital. Nothing remotely close to what the witness described happened with me or any other officer on the scene. They knew this and put the witness on the stand anyway.
There was no regret or remorse on behalf of Amiot, and it was clear that an apology was too much for this ego-driven officer.
I take full responsibility that there was a failure on my behalf to get Mr. Hubbard in custody quickly. The incident was prolonged when I was shot with the taser. During the deployment, I broke my hand, ruptured tendons, and injured my shoulder. I want to end by saying I'm not an advocate for or against use of force. Everything I did on that day was based on my training and experience. From here on out, I'll be an advocate for subject control training department-wide going forward so we can all be at our best when the time comes. I have a deep respect and love for the citizens and this community. I want to do my best to serve them.
Finally, it was time for the judge to speak, and before announcing the much-awaited sentence, he had some words for the officer himself.
One of the things that stood out to me is that the initiation of this incident probably never should have occurred. When you receive that initial radio communication, that initiated this whole thing. And the other thing that sort of stood out to me was that in approaching the vehicle and asking Mr. Hubbard to get out of the vehicle, there was an inability for him to get out of that vehicle without making contact with you.
The judge, who also happened to be a black man, spoke to the victim and assured him how he should move on from this terrible incident and not let the corrupt officer's actions ruin his life.
I believe the jury got it right. I do. And the court must impose the sentence that the court feels is appropriate in a case like this. And I appreciate if you need assistance, you need to go and get that assistance. But I'm not going to say you're not going to have instances of flashback or what have you, but you need to move on with your life also. And not let this incident continue to hover over you. The city compensated you.
Ultimately, the sentence was announced and Amiot was removed from the court.
Court at this time will impose a sentence of 90 days, require you to pay a fine of $1,000, and will require you to pay the court costs. In addition, the court will suspend the sentence of 90 days, place you on non-reporting community control for a period of 1 year. If you violate during that 1 year, then the court will retain the ability to impose the sentence. Anything on behalf of the state?
No, Your Honor.
On behalf of Ms. Amiot?
Just what count is this in?
The court will use the assault as opposed to the violation of civil rights. Not saying they weren't violated, but given the length of time, the court will use the assault charge. Anything else?
He was initially sentenced to 90 days in prison, but that was later canceled. Instead, he was placed on 1 year of non-reporting community control and fined $1,000. He was also rightfully fired from the Euclid Police Department. This officer certainly earned his karma, but things took a bizarre turn when his qualified immunity was revoked.
He had nothing in his hands, and he was shot twice in.
In 2011, a simple traffic stop turned fatal when Officer Osvaldo Villarreal shot and killed innocent Benny Herrera. After a few years, his family filed a lawsuit against the cop, which eventually led to this pre-trial.
This is a tragic case, there's no question about that. But Officer Villarreal was required to make a split-second life and death decision.
What required him to do that? It doesn't look to me as though he was the initiator.
The fact that Mr. Herrera, first of all, he had been acting erratically before the shots were fired. He moved from a place of relative safety on the shoulder of the road into the roadway. He was skipping.
But if we're talking about Officer Villarreal, how much did he know about the prior behavior?
He saw all of that.
I have to say what you're saying is inconsistent with what I saw on his own camera. That is to say, the point at which he began to get close enough to see anything. Some of that earlier stuff was on the other camera, but not on his.
Shockingly, it only took a few seconds for the corrupt officer to draw his weapon and shoot innocent Herrera, although Herrera was unarmed at the time.
His camera was turned on, but
His camera was turned on well before he got to the scene.
He testified in deposition that he saw Mr. Herrera on the side of the road, and then he saw. Well,
he can testify to what he wants to testify to, but I want to tell you what I saw on his own camera tells me that the early part of this he did not see, could not see. That was his intention, you say?
That was his intention, and that's in his deposition.
Again, I'm relying on what's on the videotape, and now this is in Officer Villarreal's car. I hear him say, "Take your hand out of your pocket," and I hear the gunshot almost simultaneously.
Exactly.
They cannot be separated by more than a second.
And that's exactly the time period when Officer Villarreal had to make his decision.
To make matters worse, the officer had been cleared by the police department. It is shocking to realize the level of accountability that these cops have.
Before, he was asked in deposition, well, what were you going to do when you asked him to take his hand out of his pocket? Well, I was going to put him in a control position. That's what he intended to do.
So he's taking his hand out of his pocket.
Yes.
And as he's obeying the officer's command, he gets shot.
But it's the way that he does it, Your Honor. He didn't just stand still and take his hand calmly out of his pocket. Is he doing this peacefully? Or does he have something in his hand that could be a threat to me and is my life in danger?
Well, right.
He had a fraction of a second to make that decision.
Well, don't we have to view this in the light most favorable to the plaintiff here? I mean, and so if we do what you just said right now, offer two possibilities.
However, the body cam footage made it very obvious that the officer was in the wrong, and the judges also felt that his qualified immunity needs to go.
Here, Mr. Herrera was arguably complying with Officer Villarreal's order to remove his hand from his pocket at the time that he was shot. So how is it that we determine that we should grant qualified immunity?
Because qualified immunity allows for police officers to make mistakes. It allows for the possibility that officers will make mistakes in judgment, and that's exactly what happened here. Officer Villarreal had a choice to make. Do I wait and see whether there's something in the hand that could kill me, or do I shoot? And he made the decision to fire. We know with the benefit of hindsight, obviously, that was wrong.
It's truly saddening how Officer Villarreal was getting the cops' privilege. There was absolutely no reason to shoot the victim, and he should be getting punished for it. But thanks to the legal system here, he remained on the force without any trouble.
It seems like he had a better vantage point possibly than Mr. Villarreal.
He actually didn't, for these reasons. Officer Miali was facing, from his point of view, he saw Mr. Herrera's back, not Mr. Herrera's front. So he couldn't see, and he testified in his deposition that he couldn't see Mr. Herrera's hands as they were coming out of his pocket. He also, if he had fired, he would have fired toward an apartment complex. Officer Villarreal fired toward a block wall.
I guess the issue I'm having here is that these are arguments, in my mind, for a jury. That certainly you can lay these out, but we're at a very limited scope here. This is not jury redo. We have to determine based on the facts as alleged by the plaintiff. And right. they're gonna say, no, it was, he simply had his hand in his pocket and these officers were coming up on him really strong. They created the tension, they rose the adrenaline, not him. You have to lay out, take their facts, not the facts as you want. You gotta stick with their facts and explain why under their facts, you win as a matter of law.
I agree, Your Honor.
However, things were now starting to look tough for the corrupt cop, and finally, the judges were reaching some sort of justice for the deceased and his family.
As long as the historic facts are undisputed, the question of whether or not Officer Villarreal's actions were reasonable is a question of law. It's not a question that you give to a jury, because we don't want juries second-guessing the very, very difficult life and death decisions that officers have to make.
I agree, but at this stage, again, this is not an argument to a jury. Take those facts. You're saying that as a matter of law, the shooting here was legal.
Yes,
those
it was objectively reasonable. Well, not just those facts. Officer Villarreal knew that Mr. Herrera was a suspect in a domestic violence incident.
Okay.
He knew that he had a gang affiliation, that he was on parole, that he had a warrant out for his arrest. All of those things factor into
on parole. I don't remember on parole. They said
on parole, yes, and there was a warrant out for his arrest.
What do we know about what Officer Villarreal knew with respect to whether he was armed?
We know that dispatch told Officer Villarreal and Officer Miali that Mr. Herrera was not known to be armed.
The judges argued that the officer should at least be tried, as the other party had substantial evidence to challenge his qualified immunity.
Espinosa, the suspect, had refused to put up his hands, had threatened the officers, and an officer believed that she saw something in the suspect's hand, saw him move his arm, and was worried he was going to shoot her. But yet we affirmed the denial of qualified immunity in part because the suspect had not brandished a weapon or spoken of a weapon.
The defense attorney worked hard to portray her client as innocent, but the judge wasn't having it and quickly shut her down.
The domestic violence incident was over.
Yes, and there...
So, I mean, how does that strengthen your case? I mean, that was, if you're arguing that it was an ongoing domestic violence, so...
it wasn't an ongoing domestic violence incident. And it's easy for us to sit in hindsight and say, well, Mr. Herrera didn't have a gun. Mr. Herrera didn't really pose any
I don't think
threat.
anyone here said that one time.
No,
I think what we're focusing on, again, the narrow standard we have to deal with here, and that's what we're dealing with. This is not a jury trial. This is not summary judgment. It's a very limited thing. No one here has raised about the fact he didn't have a gun.
I understand. The trial court did.
After the defense presented their side, the plaintiff's attorney took the stage and raised several crucial questions.
But I think there's no question that he had his hand in his pocket.
Well, and both officers said it looked like he had something heavy in his pocket.
Okay.
All right. And then just before Mr. Villarreal opened fire, Mr. Herrera rapidly removed his hand and moved quickly, it seemed like, toward the officer's car. Why isn't that enough?
Well, because sticking on the undisputed facts, the officers had no information that any weapon was involved in a crime. They were specifically told he was not known to carry weapons.
The attorney made it clear that it was entirely the officer's mistake to escalate the situation to this alarming level.
Opposing counsel that he's entitled to make a reasonable mistake.
Well, if that was the standard alone, then every single shooting case, the defense would argue that an officer is entitled to a reasonable mistake, and that's the end of the analysis. I think for purposes here, one has to look at the facts supporting the plaintiff's version, and he had nothing in his hands, and he was shot twice and killed. We specifically asked the officers about their training, and they conceded, which is included in the cites in our brief.
No matter what the defense argued, the facts were clear. Herrera was dead, and Officer Villarreal was responsible for his death. Still, the defense tried once more to sway the judges.
The jury does not get to decide qualified immunity?
Qualified immunity is a question of law for the court.
You mean, so depending on, the jury has to decide whether or not there's been a constitutional violation, and at trial the jury cannot say to your officer, you're off the hook because you have qualified immunity? That can't be right.
The underlying predicate facts.
I understand that, but I think I'm arguing on your point. If we send this back, I don't think you want to say qualified immunity is no longer available to you at trial.
Absolutely not.
Well, I think that's what you just said. That's why I'm speaking up.
That was not my intention at all.
Once again, the judges stood firm on the right side of the law and shut down the defense attorney's argument.
Everything goes bad for your client. That is to say, if we send it back, if the jury says no qualified immunity, and if the jury comes in with an award of some amount of damages, will your client pay those damages out of his own pocket, or will it be paid by his employer?
It should be 99.9% of the times it's paid by the employer. I don't see why it would be different.
Well, by
in
statute,
this-
California statute says it's paid by the employer unless they're punitives.
Yes,
Isn't that right?
that was what I was going to say.
So that doesn't say 99%, it says 100.
Well, I was going to say, unless there were, if there
Unless they're
were
punitives.
If there were punitive damages, the city would have the option of deciding whether to pay those punitives.
Justice was eventually served when Officer Villarreal's qualified immunity was abolished. A trial was later called, with the judges concluding that unlawful deadly force was used in the incident. As the case was headed to trial, the city also compensated Herrera's family with $1.4 million. Well, that brings us to the end of this video. Today we witnessed some of the most brutal karma delivered to corrupt cops in the courtroom. It is always satisfying to see these officers face justice, and there is no better place for it than in a courtroom. If you agree with me, please support us by liking this video. Also, if you enjoyed this video, watch how these good cops stood up to the bad ones and owned them badly.
Get the dog off of it! Get the dog off of it! Get the dog!